Welcome, everybody. My name is Paula Price, and you are here for Tired of 2 Meters, Everyday Legal Issues During COVID Fatigue. It's a webinar that is brought to you by the People's Law School with our speakers from Forte Law, Community Legal Assistance Society, and Harper Gray. And before we begin, I just wanted to say that we're really excited to bring this webinar to you. We are now about 9 months into the pandemic. We have a number of restrictions in place within the province. Our holidays are coming up. They are going to look very different from holidays in past years. And, the challenges that we face at this stage of the pandemic are somewhat different from the challenges that we faced at the beginning of the pandemic. And we're lucky to have three incredible speakers who are going to speak to us about some of the everyday legal issues that are arising in our day-to-day, including in the areas of employment, human rights, and public health law. And we're moments away from introducing our speakers, but before I do that, I would just like to acknowledge and make some expressions of gratitude to those of us in our community. First, we acknowledge that the land on which our People's team is gathered is the unceded territory of the Coast Salish peoples, made up of the Musqueam, Squamish, and Tsleil-Waututh First Nations. We'd also like to acknowledge BC's frontline workers, and there are those who are working in hospitals directly with the people affected by the virus, and clearly we extend them greatest gratitude. But also we'd like to express gratitude to all the people who make it possible for us to continue living our day-to-day lives. So the clerks at our grocery stores, the teachers in our schools, we're all playing a role in this together. I'd like to acknowledge everybody who has signed up for today's webinar and who is on the line right now. This has been a wonderful year for People's Law School. It's the first year we've been doing the webinars, and we've been able to reach so many of you through our work. And it's because of you that we create these webinars, and we love your participation, your questions, your feedback, and we continue to try to make our webinars responsive to what you are interested in learning about. And the fact that you are taking time out of your busy schedules to learn more about your legal rights is wonderful. And I just want to acknowledge all of you for being here today. We'd also like to acknowledge the Law Foundation of BC. They are the primary funder for the People's Law School, and they make this type of programming possible. And you've all been waiting for our guests. Of course, a big acknowledgement and gratitude to our speakers today. We have Laura Track. Laura is the Director of Education and a lawyer with the Community Legal Assistance Society. And we're really excited to have Laura here today. Laura has helped the People's Law School by reviewing some of the pages on the website. And it was really great speaking with Laura because human rights, I think, is a term that gets thrown around quite a bit without us really understanding what those rights are. And Laura is going to be able to help us understand what rights are protected and the limits on that protection, and to give us that information in the context of the global pandemic. So Laura, thank you so much for being here today.
My pleasure. Thank you so much for the invitation.
We're so great, so delighted to have you. Thank you. We've got Jessica Foreman joining us from Forte Law Employment Law Solutions. And Sarah Forte and Jim Wu were also from Forte Law. We're here in the spring to help us through some of the challenges that workers were facing at the beginning of the pandemic. And so we're really pleased to have Jessica join us here during our final webinar of the year. And Jessica is an employment lawyer. She represents both employers and employees. Jessica, thank you so much for being here today. It's so nice to see you again.
Thanks, Paula. I'm really excited to be here as well.
Super, thank you. And finally, we have Dion Liu. Dion is a lawyer in health and insurance with Harper Gray. And Dion brings a very special piece to this equation. Throughout the pandemic, we have been asked to put restrictions on the things that we do. So, our Christmas holiday or whichever holiday you celebrate are going to look quite different this year. Every time you step into Safeway, you need to put on your mask. And as we do these things, I think it's really interesting for us to hear the perspective of what this looks like from a public health perspective and why it is that we do what we do so that we can really feel good about the contribution that each of us is making as we make our way through the pandemic. So Dion, really, really delighted to have you here. Thank you so much. Welcome.
Thank you for having me.
Thank you, Dion. And with that, we're going to turn to our questions. These are questions that we have received in people's law school and questions that our lawyers have received in practice. So the first one is for Laura. And before I ask the question on the screen, Laura, I'd just like to ask you to let us know a little bit about CLAS and what it is that you do there. Oh, and Laura, you're on mute, so please.
Of course I am. Somebody
Wonderful.
has to
Now
do
I
it
can hear
once.
you.
I've cleared the way. Now nobody else will do it. You're welcome. Sorry about that. Thank you for the opportunity to join you today. I'm joining you from the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh people, which is where CLAS is located. CLAS stands for the Community Legal Assistance Society, and we're a nonprofit legal organization that's been around for 50 years now. Since 1971, we're celebrating our 50-year anniversary next year. And we provide free legal services to low-income people in British Columbia in a variety of different areas, including poverty law, mental health law. We have a new workplace sexual harassment project. And then we have our human rights clinic, which is where I work. The Human Rights Clinic assists people who have made human rights complaints to the BC Human Rights Tribunal. And we have a range of services for folks, including a telephone inquiry line that's staffed Monday to Friday, a Monday clinic where people can sign up for a half an hour of legal information and advice about a specific problem they may be dealing with. And then we have lawyers and advocates on staff who can represent people through a human rights complaint process. So that's a bit about us.
Excellent. So I imagine you've been pretty busy throughout the pandemic.
We certainly have. And the question that you have there on your screen is probably the number one question that we've been receiving, at least in recent months. Can a business require its customers to wear a mask? It's a really common question. It's one that we field on our telephone inquiry line all the time. And we have a blog post on our website on this topic, so folks can consult that for a bit of additional information. And I also want to flag that the BC Human Rights Commissioner, Kasari Govender, in her office has also published some guidance and best practices on the issue of mandatory masks and accommodations that may be required under human rights law. So the short answer to the question is that yes, businesses can require patrons to wear a mask in order to enter their business or access their services. And in light of the recent public health order that I know Dion is going to tell us more about, business actually must do so. But even before the revised order that came out a few weeks ago, a business was well within its rights to require customers to wear a mask. In the same way that a business can require people to wear a shirt and shoes in order to enter the business and receive service, a business can also require people to wear a mask. That said, customers with medical conditions that prevent them from safely wearing a mask have rights under BC's Human Rights Code to be accommodated to the point of undue hardship for that business. The Human Rights Code in BC protects people from discrimination on the basis of a disability. So if someone has a disability that prevents them from safely wearing a mask, the business must take reasonable steps to accommodate them and to ensure that they're not denied service. And I've referenced disability. There might also be other protected groups under human rights legislation that would require accommodation with respect to mask wearing. Someone who wears a religious face covering, for example. It's important to note, however, that simply a personal preference not to wear a mask would not be protected under human rights law.
Excellent. Thank you so much, Laura. And those resources that you mentioned, the blog post and the posting from the Human Rights Commissioner, we have those, they'll be included on their website, and I think they're probably also being included in the chat function today. So thank you so much for sharing that with us. Laura mentioned the public health order, and John, we were hoping to ask you, what exactly is a public health order, and how does one get issued?
Right, so I think that that's certainly something that's top of mind these days. I think that the starting point is going to be that we've got two pieces of legislation in BC. One of them is the Public Health Act, and the other one is the Emergency Program Act. And both of these statutes that the legislature has put in place allow for orders to be made in certain circumstances, and in the context of public health emergencies or the state of emergency, which we are currently in. And I think that an important thing to remember about these two acts is that they are things that pre-existed the pandemic. So prior to COVID, prior to March, when we declared the state of emergency, they did exist. And they allowed, for example, for public health to deal with things like other infectious diseases. If you think about HIV, AIDS, TB, and those types of things, they're all dealt with under that. And there was also a pre-existing Emergency Program Act. What the declarations of public health emergency and the state of emergency do is that it gives some slightly augmented powers to do things. And so we've talked about, or we've mentioned the concept of a public health order. And so that is something that the public health officer, Bonnie Henry, is able to make under the Public Health Act. And there are certain conditions that have to be met in order for her to be able to do so. So for example, when we think about the traveler orders and the orders that pertain to them, the Public Health Act allows for the public health officer to make orders when they have a reasonable belief that a person is infected, and that the order is necessary to protect public health, and the order is necessary to prevent transmission. And this idea of necessary is one that kind of permeates the requirements for when a public health order can be issued. And so in the context of travel right now, we've got an order from the public health officer saying that persons who have traveled from outside of Canada have to self-isolate. And the basis for that order is set out in the physically written order, is that persons that are traveling from outside have or likely may have been in contact with COVID. And so their isolation is required and necessary in order to prevent transmission. And so similarly, when we're thinking about the more sort of recent public health order around gatherings, there's also this requirement of necessity. So the public health officer has to reasonably believe that there is a health hazard. In this case, they've considered that the risk of a COVID outbreak is a health hazard, and that this order is necessary to reduce the rate of transmission. And so again, it comes back to this idea of, you know, believing that there is this risk there and that this order is necessary. And I mentioned the Emergency Program Act, and again, that is another act that allows the government to make certain orders. Those are called ministerial orders made by the Minister of Public Safety. And that's actually the order that the act that the mask order has been made under. And it allows the government to make orders that are necessary, again, you hear that word, to prevent or respond to things that are arising from the state of emergency, in this case, the COVID pandemic. So, you know, I think that the common thread that you'll hear is this idea of necessity and tying it back to the pandemic. And that's, the legal framework within which the government, even prior to this pandemic, had set out for when they can make these orders.
Thank you so much, Gian. So, I mean, it really is clear that this is the exercise of authority that was predetermined, and we're really looking at the necessity of making these restrictions. Laura, going back to the human rights aspect of it, generally, what protections then are in place for human rights?
Yeah, so I'm just checking I'm unmuted. Yes. Okay. So human rights are protected in BC by a couple of different laws. First, the BC Human Rights Code, which I mentioned earlier, which prohibits discrimination on the basis of a list of protected characteristics, such as your race, religion, age, disability, sexual orientation, and so forth. There are about 15 protected characteristics listed in the code. And the Human Rights Code applies in three key areas of daily life: our employment, our housing, and our access to services and facilities that are made available to the public. So, for example, we know that throughout this pandemic, people of Asian descent have been targeted by racism and occasionally by violence. While the code doesn't apply if the racism or violence happens, say, while you're walking down the sidewalk or waiting for the bus, two real examples of racist violence that people of Asian descent in Vancouver have experienced during the pandemic. The code doesn't apply in those situations, but it does apply in our workplaces. And employers have a duty under the Human Rights Code to proactively address any racism that occurs in the workplace by ensuring things like policies are in place and that any incidents of discriminatory treatment are responded to promptly and effectively. And it's important to note that those workplace protections from discrimination apply in virtual workplaces as well. The fact that we're now, many of us, working from home does not relieve employers of their duty to take action in response to discrimination. I also want to mention, because many members of the audience will be familiar with, the rights that are protected by Canada's Charter of Rights and Freedoms. The Charter is part of Canada's Constitution, and it applies to the government and to government action. And charter rights have also been impacted during the pandemic. Our freedom of assembly and freedom of association has been impacted by the limits on gatherings and by social distancing requirements. Our mobility rights have been limited by the restrictions imposed on travel. Our right to life is also very much impacted by this deadly virus and the measures that are taken or are not taken to control it. Now, whether we're talking about the Charter of Rights and Freedoms or the Provincial Human Rights Code, human rights often require balancing or figuring out how different rights and different people's rights can fit together. Our rights are never absolute, and limitations on our rights can be justified when there are good reasons for those limitations. With respect to charter rights, the very first section, section 1 of the charter, provides that the rights that it protects can be limited in reasonable and proportionate ways. With respect to the Human Rights Code, employers and service providers and housing providers can justify rules or policies that negatively impact people who are protected by the Human Rights Code by showing that that rule or policy is reasonable in the circumstances. To show that a rule or policy is reasonable, they're going to have to show that they did everything they reasonably could to avoid the negative impact on the protected person. In other words, they have to show that they accommodated the person to the point of undue hardship. So we've seen a number of human rights issues arise during the pandemic where this duty to accommodate under human rights law is very much in play. Some of the situations that we have seen arise include employees with pre-existing health conditions or other disabilities who may be at increased risk of infection from COVID-19. So what would the duty to accommodate require in those circumstances? Well, perhaps an employer needs to take extra measures to keep those employees safe during the pandemic. For example, an accommodation might involve allowing them to continue working from home and avoid risks in the workplace or on transit on the way to and from the workplace. Even though maybe other employees are returning to work, accommodating that particular employee's unique disability-related needs might involve allowing them to continue working from home. One other example of duty to accommodate situations I know many employers are grappling with during the pandemic, although I think maybe things have improved somewhat, but is around childcare. And for anyone listening to this webinar who has small kids at home, I feel for you, and I am sure that many of you can relate to the challenges that parents experienced, in particular in the first few months of the pandemic when schools were closed, daycares were closed, even through the summer while usual activities and camps were running on really restricted bases. Employers have a duty to avoid discriminating against employees on the basis of a protected characteristic called family status. And family status has been interpreted to include childcare obligations. So accommodating an employee's need in relation to providing care for their kids, again, may involve adjustments to normal workplace rules or policies or hours, et cetera. And I know that that's one, as I say, that many employers certainly were navigating through the early days of the pandemic and probably still are to a certain extent.
Thank you so much, Laura. That's an excellent overview of the human rights, the framework, and also how it presents in the workplace. Jessica, speaking of employer obligations, a number of workers, as Laura pointed out, are working from home and continue to work from home. And our next question is, what are an employer's obligations for those employees who continue to work from home?
Yes, and this is a question that we are getting a lot of, both from the employer perspective and the employee perspective. And one thing that you're going to probably hear me say a few times today in this discussion is that employers are responsible for ensuring the health and safety of their employees. And that is a requirement that all employers have, and that extends to those employees who are working at home, not just the employees who are still working in the workplace. So WorkSafe BC has provided a number of guidelines, and it requires every employer to have a work from home policy, an actual written policy that sets out a number of things with respect to those employees that are working at home. It includes things like employees have to assess their workplaces to make sure that they're safe, evacuation plans in an event of an emergency, how to report workplace injuries if you're at home, ergonomic considerations to ensure that employees are comfortable and safe and don't suffer workplace injuries because they don't have a proper setup with their chair or their desk or their lighting, for example. It also requires employers to communicate and check in with employees who are working in isolation or alone. So every employer who has employees working at home is required to have a policy and to follow through on that policy with respect to those employees. Additionally, included in the health and safety requirements that an employer is responsible is they're required to ensure that the mental health of their employees. And we're seeing this issue come into play a lot right now during COVID as people are experiencing increased levels of anxiety and stress and isolation as a result of the pandemic. So just as employers were always responsible for ensuring their employees' mental health, that obligation remains true today and for those employees working at home. And there are a number of resources on the WorkSafe BC website for employees to access. But I'll just mention a couple of things that we talk regularly to both employers and employees about with respect to this really important issue. First of all, we encourage employers to educate employees and to make sure that they understand what resources are available for them, and also to assure them about whatever safety precautions are being taken in the workplace so that workers feel more comfortable and less anxious. Secondly, communication really is the key. For both employers and employees, they should have open communication about these issues related to mental health. And so I encourage all employees who are feeling anxious or worried or suffering from any mental health issues right now to please reach out to their employers, as it's their obligation to support them and to help them. And similarly, we encourage our employers to make it a regular part of their conversation with their employees to check in. On that, confidentiality is key, and employers must ensure that anything that employees share with them about any of their health issues, but especially mental health issues, are kept confidential. And lastly, we encourage both employers and employees to stay connected, whether it's checking on staff regularly, doing video conferences, or having other ways for employees to connect. Those are important strategies for employers to help continue to ensure that their employees' mental health is protected. And again, lastly, I encourage anybody who has additional questions to look at the WorkSafe BC website, where there are numerous resources, phone numbers and guides to help you navigate this very, very stressful and difficult time that I know many employers and employees are both feeling.
Thank you so much, Jessica. I think those are such important points, especially as so many of us work remotely, and with the additional challenges of the pandemic and the impact that it has on everybody's mental health. It's really good, I think, to let people know that there's help for them if they need that help. So thank you. It's such a great point. Looking at it from another perspective, there's a lot of talk now that we've got the vaccine in the works, a lot of talk about whether employers can require their employees to become vaccinated. What are the rules around that?
Well, and this is very, very top of mind. A colleague of mine actually was interviewed last week on CBC discussing, or CTV, excuse me, discussing this issue. So I know this is on the minds of employers and employees. And what I can tell you is that with the current language in the public health order, at this point, employers cannot force or require their employees to get vaccinated as a condition of their employment. And what I mean by that is right now, an employer cannot tell an employee they have to get vaccinated or else they will lose their job. Now, it is possible that the public health order language that Dion spoke about will change over time. And I expect that this will be an evolving area that we will have to keep an eye on. And there could be certain requirements for certain sectors like the healthcare industry or the long-term care homes. But at the moment, there isn't a blatant ability for an employer to require an employee to get vaccinations. Now, regardless of that, of course, an employer can certainly recommend and encourage their employees to get vaccinated. Employers could and should educate their employees about the benefits and point them to the public health information that is available so people have the accurate information about the risks and the benefits. Employers should provide any employees who need to get vaccinated the time to do that, and obviously set an example if they want and hope their employees to get vaccinated, to do so themselves and to make it a real open conversation in the workplace so that everybody is working together to do what our public health officers are suggesting. The other questions we often get with respect to public health orders and what employers can do is sometimes related to when an employee is required to quarantine or isolate as a result of either a COVID exposure or because they've been mandated to from a public health officer. And of course, employers are required to provide their employees with time away from work or allow them to work remotely if they do have to quarantine or isolate as a result of a COVID exposure or because they've been instructed to do so from a public health officer. And of course, at the outset of this pandemic, BC introduced a new COVID leave, which allows employees to take unpaid job protective leave if they're quarantined or in self-isolation. And what that means is that an employee's job is protected if they're required to isolate or quarantine. They cannot be fired for having to do so. However, there is no requirement that an employer provide an employee with paid time off for the quarantine. So many employers are doing so, those that are able to, but the requirement as of now is that employees are required and allowed to take unpaid time off if they're required to quarantine or self-isolate.
Excellent. Thank you so much, Jessica. Dion, this next question is for you. And the question here is, what if you don't do something mandatory, such as not wearing your mask in an indoor public setting, or you don't comply with your self-isolation after you travel?
Right. So, anything that is required under an order is something that has legal repercussions to it if there's a failure to comply. And, folks may have heard on the news about fines being issued for people that have engaged in gatherings in contravention of the public health orders. And that's where that comes from. So most of the public health orders that kind of affect day-to-day activity are backed as well by a corresponding ministerial order, which means you can be issued a ticket for violating, and that ticket is accompanied with a fine. And I think that if you go on to the government's website, they have indicated what the dollar figures are for each of those tickets. So, that would apply to the mask, and that would apply to, not gathering or gathering in contravention of the orders. The thing to keep in mind, and the government has not indicated that they would go this far, and I think that it would take something severe in order to go this far, but when there is a contravention of an order under one of these acts, those acts have provisions that say that can lead to a regulatory offense charge. So it's not the same as a criminal charge, but it can end up in fines that are much more severe, so in the thousands of dollars. And the courts do have the option of imprisonment as well as part of the sentence. I think that this is probably quite unlikely to happen, but just something to bear in mind that is within the court's power to do. So definitely, would make sure that you're aware of what the orders are, so that you can be informed when you're making decisions about how to act. And I think that the best thing to do, my recommendation is, look at the government website to make sure that you know what the orders are, because they have put out in writing what the orders are, and that way you can be informed about that.
Excellent. Thank you so much, Dion. And you shared a number of resources with us, and those will also be included with the recording of this webinar. So that should be a resource for anybody so that they can look those orders up. Thank you. So our next question is for you, Jessica. Can somebody get fired? Let's say they're not complying with an order. Can they get fired from their job for not doing so?
Yeah, unfortunately, the answer to this question, Paula, is one that we as lawyers are often giving to our clients, which I know can be frustrating. And the answer, of course, is it depends. And I know that it's really frustrating not to have clear yes or no answers to some of these issues that are really top of mind. But this is one of those really gray areas of law that does depend on the particular incidents of what the person is alleged to have done and what the job is that they are doing. What this question relates to is something that we call off-duty conduct. And this idea of, can an employer take disciplinary action against an employee for something they do outside of the workplace comes up regularly, not just in the COVID context, right? We've routinely heard about this when there are employees posting things on social media or behaving badly at a weekend party, for example. So this idea of off-duty conduct or something you're doing outside of work is something that routinely comes up. What I would say is that there are very limited circumstances where off-duty conduct would result in termination of employment. It would need to be conduct that was really, really that harmed the interests or the reputation of the employer, for example. Those are often the language that's used in that analysis. And one of the main factors, besides looking at what the person or individuals did, is what kind of job they have and in what sector. For example, someone in a very public position or a CEO of a company who behaves badly may in fact be disciplined in a different way than a different kind of employee would be. Additionally, if you worked in childcare or healthcare and were doing things that were putting other employees at risk, that could be grounds for a discipline. But it is, again, difficult to say an automatic yes or no. And what we encourage all employers to do who have asked us about this question is to continue to recommend and encourage their employees to follow all of the public health orders so that they don't, have to deal with these issues as they come up.
Excellent. Thank you, Jessica. And like so many questions that come up in law, it really is dependent on the situation, the facts. Another question for you, Jessica, which I understand you've also received a lot of recently, is what happens if my temporary layoff has become a permanent layoff?
Yes, and we have on the employer side, we've had a number of these situations where employers have come to us and said, we had temporarily laid off a bunch of employees in hopes that things would turn around economically for us, and we cannot hire them back, and we're going to have to let them go. And similar, we've heard from a number of employees who have been in that position. So if an employee who was on temporary layoff is now told, I'm sorry, your job is not available, and they're laid off, whether their employer calls it a permanent layoff, a termination, or fired, they all mean the same thing. It means your employment has ended, and you as an employee are entitled to severance pay of at least the minimum under the Employment Standards Act. And the act sets out a very a set amount that employees are owed based on how long they've been working at a particular job. And it's important for employees to know that when you are calculating your service or the amount of time you've been working, that your temporary layoff counts as part of that. So if you were temporarily laid off for 2 months and then permanently laid off, that 2-month temporary layoff counts in your overall time of working for figuring out your severance. Another thing that an employer is required to do at the time that your employment ends is to issue a record of employment, otherwise known as an ROE. And that is the document that an employee would need if they're going to go and try to get employment insurance. So when an employee is looking at what they're owed at the end of their employment, as I said, they're required to be paid at least the minimum under employment standards, but some employees are entitled to more. And that depends on whether they have a written employment and contract that may say what they're owed at the end of employment. And other employees are entitled to what's called common law notice. And these issues of what you're owed and whether you're treated fairly can be very complicated. And it is my advice that if you're in that situation and you're not sure about whether or not you're treated fairly, that you seek some legal advice, whether it's through an employment lawyer or the Employment Standards Branch or some free legal advice, because the lawyer can help take a look at your situation and let you know whether or not you have been treated fairly and paid everything that you're owed. Now, I'm going to talk very briefly about what happens if an employee decides they're not happy with what they've been paid, or a lawyer advises you that you've been wrongfully dismissed, and what your options are. So one option is that an employee can file a claim with the Employment Standards Branch. And that would be a complaint where you can seek your severance entitlement, wages, overtime, vacation pay. There's a number of different things that you're required to be paid at the end of your employment. And if you're not paid those amounts, you can file a complaint with the branch. And those complaints are really meant to be done by individuals without the help of a lawyer. And the Employment Standards Branch has people available to help you do those. The other option is to file a lawsuit or a notice of civil claim in the BC courts for a wrongful dismissal. And if that's something you're thinking of doing, again, my suggestion is that you get some legal advice. The idea of starting litigation or filing a complaint is something that you should go into with your eyes wide open and all of the information available to you. The process can be very long, especially right now during COVID, where the tribunals and the courts are very, very, very backed up. So the process from filing a claim until you get to a hearing can take quite a long time, sometimes 1 to 2 years. The other thing you want to know is that if you're filing things in court, the documents are public, both your claim and whatever your employer files in response, and decisions are also publicly available. So the bottom line about litigation or deciding to sue your employer is that it can be very expensive. And even if you win in the end and you are told that you're entitled to much more money, you may have spent a lot of that in legal fees along the way, and it can be very stressful. So some practical advice that I use with both employers and employees to try and avoid litigation is from the get-go to have good and open communication. If you're let go and you don't understand what you've been provided or whether or not it satisfies your obligations, speak to your employer, ask for clarification, and if you're still not sure, get some legal advice. Often what we do is we help advise employees behind the scenes to help them have some information to go back to their employer and explain why a severance package is not fair or why they might be entitled to more. You can also get help from the Employment Standards Branch. They have people available and guidelines available for individuals who are looking to understand what they're owed and to make sure that they're being treated fairly, and to guide you through the complaint process if you want to. So that's just a general summary of what happens if you get laid off and the steps that you can take. And again, I'll just say one last time is my advice is before signing things or before agreeing to a payment, have a lawyer take a look at it, make sure you understand what you're signing, and make sure you're adequately protected.
Excellent. Thank you so much, Jessica. Our last question in the prepared questions is for you, Laura. And how would you go about, if you had a human rights complaint to make, how would you go about making that complaint?
Yeah, a lot of similar things apply in the human rights context to what Jessica was describing. It can be time consuming and lengthy and stressful, and all of those things are true with respect to a complaint. A human rights complaint is certainly less formal than a court action, but it is still litigation. It is still an adversarial process. Proceedings are public, decisions are public, and the tribunal is very backed up. We're hearing folks waiting quite a long time, even just to have their complaint screened and accepted for filing by the tribunal. With all of that said, though, it is an accessible forum. It is quite straightforward to make a human rights complaint to the BC Human Rights Tribunal. And just to be clear, I'm only speaking on this question about making human rights complaints to the Human Rights Tribunal, not about charter litigation, which is much more complicated, much more expensive, and which I would highly recommend folks seek legal advice from a constitutional lawyer with experience doing charter claims. But in respect of human rights complaints about discrimination in employment, housing, or access to a service, you can make your complaint to the BC Human Rights Tribunal. The form is available on the Human Rights Tribunal website. You can also prepare your complaint online and submit it that way. Important to note that you must make a complaint within 1 year of the event that you allege was discriminatory in order for the tribunal to be able to process it. It is completely free to start a human rights complaint, so anyone can go onto the website to download the form or fill out the complaint online, and there's no cost for doing so. As I say, it will take some time right now for your complaint to be screened by the tribunal, but once it is, the tribunal will let you know, okay, your complaint's been screened, it's accepted for filing, and at that point they send the complaint to the respondent and the process begins. Most complaints at the Human Rights Tribunal go to mediation. Many complaints get resolved at mediation, and mediation can be a quick and satisfying alternative to the lengthy complaints process. The tribunal will provide the parties with a mediator, with space to have the mediator if it's in the in-person times. Otherwise, mediations these days are happening over the phone or by a video conference tool. And as I say, many complaints do get resolved through that process because it allows the parties to come to an agreement about what a fair resolution looks like, and helps them avoid the lengthy 1 to 2 year process that the rest of the complaints process can entail if you go all the way to a hearing and ask for a decision by the tribunal. So that's just sort of briefly what the process looks like and how you can file a complaint.
Excellent. Thank you so much, Laura. So we're going to move into our live Q&A. So I'm just going to stop my screen share. And the first question that we have is actually one from one of our guests who wrote in before the event. And it's for you, Dion. If a worker in British Columbia travels to visit family in Alberta over the holidays, can the employer require them to stay home from work for 14 days?
So currently the travel restrictions, assuming that this individual has been in BC for 14 or more days prior to going to Alberta, the current public health orders with respect to travel would not apply to this person to require them to self-isolate. But with respect to the question of whether the employer could require them to stay home, I'd defer that to Jessica to answer that part.
Sure, and thanks. As I said earlier, the employers aren't required to do something that's not being mandated by public health. So the answer here would be no. However, employers are required to have COVID safety plans. And if they have a particularly sensitive workplace or something that requires them to have rules about travel, even interprovincial, they could have that in their policy as long as their employees had notice of it. And therefore, then, they could take actions to enforce that policy. But short of that, no, there's no requirement for an employer to make an employee stay home in those situations.
Thank you so much, Jessica. And Dion, I'm going to switch now to one of our questions. So the question is this: if an airline denies flights for individuals who do not have the vaccine, would there be a legal basis on which to challenge this? And I'm not sure who might be in a position to answer this.
I could say a couple of things. My understanding is that airlines currently require some vaccines, and some countries require proof of vaccination in order to enter the country. So it wouldn't be out of the realm of possibility that an airline could require a COVID vaccine in order to access the services provided by the airline. And is something that, at least as far as I understand, is something that has happened previously with respect to other diseases. I would also add that the duty to accommodate will apply in these situations too. And as I've said, the duty to accommodate is to accommodate to the point of undue hardship. So what that would look like in this context is hard to predict, but a service provider like an airline would have a duty to accommodate to the point of undue hardship someone with a medical condition that prevents them from getting the vaccine. And there would also be a duty to accommodate to the point of undue hardship, potentially a religious objection to receiving the vaccine. So there would be human rights principles in play with respect to this kind of rule. How it would play out in court remains to be seen.
Thank you so much, Laura. Here's our next question. And Jessica, I think this one is for you. Can an employer force you to be tested for COVID? There are various situations for this, such as if you are sick, if you are the sick one in the office the office exposed you or a client, and if you get sick from work and it affects you long term, can you file? So I guess there's two questions here. One is, can an employer require you to be tested? The second is, if you get sick from something that happens in your office, do you have a claim for somebody at work having made you sick?
Okay, well, the answer to the first one is like the vaccinations, and it's no, an employer can't require employees to get COVID tests. Right now, public health is the one that's mandating who needs to be tested when, and we're hopeful that everybody's following that. And I would say that while I know that this is a concern, and we've started to hear this question a little bit, generally over the past several months, we have not been hearing of situations where there's a lot of tension between employers and employees over these issues. The general feeling is that people are working together and everyone understands their obligations with respect to public health. So, you know, employers can continue to encourage their employees to follow public health orders and to do what we're all expected to do. And your second question about whether or not there might be liability if somebody gets sick, I'm not aware of any basis unless there's, you know, been some real negligence on the part of the employer, right? So if an employer does have a COVID safety plan and is doing what they're required to do from WorkSafe BC and from the public health, and they're taking their obligation to keep their employees' health and safety protected, then I can't imagine a situation that an employer would be liable if somebody got sick. But, you know, I'm sure there could be some particular instance where that happens. We have to remember that all employers are required and expected to do here is to follow the guidelines and to follow public health orders. And so hopefully if they're doing that, then everybody's protected.
Excellent. Thank you so much, Jessica. Laura, there's a question here that I just wanted to ask you, following up on the human rights complaint. If you miss the 1-year deadline for a BC Human Rights Tribunal application, what remedies exist thereafter?
So the Human Rights Tribunal has limited discretion to accept a complaint after the 1-year deadline. If something is what's known as a continuing contravention, so multiple instances of the same type of discrimination that have been happening for a long time, provided that at least one of those incidents happened within the last year, the older events can also form part of the complaint. The tribunal also has discretion to accept a complaint, even if it's not a continuing contravention, that's out of time if it's in the public interest to do so. And there are a variety of factors the tribunal would take into consideration in deciding whether it's in the public interest to accept a late filed complaint. One of the key factors is the reason for the delay. And I've seen complaints accepted when they're late, when the reason for the delay was related to the person's disability that is the subject of the complaint, and they were hospitalized or otherwise unable to meet the deadline because of the medical condition or disability that they're dealing with. I would suggest that if you are worried that you've missed the 1 year timeline and you still want to file your complaint, you could give us a call, sign up for one of our Monday clinic sessions, and we could talk about some of the other factors that might persuade the tribunal to exercise its discretion to accept your complaint late.
Thank you so much, Laura. We have a few more questions, but we're unfortunately out of time. I just wanted to thank our guests. Thank you so much, Jessica. Thank you, Laura, and thank you, Dion, for joining us today. It has been such a pleasure having you here, and really appreciate all of your answers to our questions and all the valuable insights that you've shared. Before we sign off, do you have any final parting words you'd like to share with our guests? Jessica, I'll start with you.
Sure. Well, I really do appreciate the opportunity to speak with everyone. And I think, my biggest message is for people to make sure that they're getting the information that they need. There's a lot of online resources. There's lots of people available to help you. And so feel free to reach out. Our blog at Forte Law has a lot of helpful information as well. And to get the information that you need to make the best choices that you can make.
Wonderful. Thank you so much, Jessica. And Dion, thank you so much for coming.
I would just echo what Jessica is saying. Obviously, these are incredible times, and it's important to just stay informed.
Super. Thank you so much, Dion. And Laura, thank you so much for joining us.
My pleasure. Thanks for having me. And I guess my last words would be, we are tired of the 2 minutes. We're tired of all of this. We're all looking forward to getting things back to normal. And our human rights are never more important than they are during a crisis, during a pandemic. It's the time where we're really called upon to be kind, to be respectful, to do what we can to ensure that rights are protected and upheld.
Thank you so much, Laura. And thank you so much to all of our speakers, and thank you to all of our guests for being here today.